Assalamualaikum warahmatullahi wabarakatuh. Good morning to everyone. So today, our next this week topic, is the judgment in default of appearance. Okay, uh, this is a default of appearance to read what will happen to your case if you don't attend court. So these are the procedures that you need to know. So we are going to cover for default of appearance to writ of summon, claim for liquidated demand, ascertained demand, a claim for unliquidated damages, claim in detinue, claim for possession of immovable property, meets claim, other claims, and proof service of writ, and setting aside default of appearance judgment. So basically, judgment in default of appearance, or known as JID, is one of the usual practice as a legal practitioner. So this is mostly covered under Order 13 of the Rules of Court 2012. So basically, these are some of the cases that you need to know, starting from Muhammad Said, Haji Omar, Hughes and Justice, UMBC, up to Syarikat Marak Jaya Sendirian Berhad. We are going to cover this later. I'm going to brief you on the procedures first. Okay, come again. Order 13, Rule 3, claim in detinue, crime of wrongful detention of goods or personal possession. The plaintiff may apply for interlocutory judgment for the delivery of the property or your value to be assessed and cost. Okay, and then uh, so basically there are two types for the delivery of the property. Another one is for the interlocutory judgment for the value of the property to be assessed and cost, and proceed the action against the other defendants with cost. Okay, and then Rule 4 is for claim for possession of immovable property. The procedure is for certificate to be produced by his solicitor, stating that he is not claiming any relief in the action of the nature specified in Order 83, Rule 3. So basically it's Order 83. If you look at Order 83, okay, you need to refer to other order as well, because basically it gives you a clear idea of what this order is talking about. So basically, Order 83 is for charge actions. Okay, for land charge action in Malay is maybe something to do with mortgage. In England, it might be called as mortgage, to do with loan. Okay, so basically that is for under this claim for possession of immovable property, for judgment to be entered for the possession of the immovable property as against the defendant and costs. Okay, and then Order 13 Rule 5 is a mix of claims. Okay, two or more claims mentioned in the foregoing rules and no other claims. And then the defendant fails to enter an appearance. The plaintiff, after the time limited for appearing, enter against the defendant's such judgment. So he would be entitled, if that were the only claim endorsed on the writ, and proceed with the action against other defendants. So if it's involved mix of claim like liquidated demand and unliquidated demand, because in some cases there, because due to one cause of action, you can have all sort of issues there. Okay, so that is for mixed claim. And Order 13 Rule 6 is for other claims. Okay, so when the defendant fails to enter an appearance, the plaintiff, after the time limited for appearing, filing an affidavit, proof that the service of the writ on the defendant has been served, and then the statement of claim was not endorsed and served with the writ, and upon serving the statement of claim, proceed with the action as if the defendant had entered into appearance. So basically, that is what it says in this order. And then application for leave to enter judgment under this paragraph 2 shall be by the notice of application unless the court otherwise order. Okay, so if it involves other claims, you file it with an affidavit and by notice of application. All right, and then the general rule. Okay, this is the thing that you must remember. Okay, for you to obtain a judgment in default of the appearance, meaning that you are the plaintiff. Okay, you must prove of service of it that is under order 13 rule 7. This is very important. Okay, so under this order 13 rule 7, the judgment shall not be entered unless under this order unless the plaintiff produces a certificate of non-appearance in form 12. This is very important. Plaintiff must file the form 12 non-appearance, and either an affidavit filed by on behalf of the plaintiff proving the due service on the defendant, or the plaintiff produce the writ endorsed by the defendant solicitor with a statement that he accepts service of the writ on behalf of the defendant. So basically, where an application is made to the court affecting a party who fails to enter appearance, the court may be required to be satisfied in such manner as it thinks with the party in default of appearance. Meaning, before you file to the court that you want to enter a judgment in default of appearance to read, okay, you must prove to the court under order 13 rule 7 that certificate of non-appearance has been filed, showing that you have served the writ of summons and statement of claim on the defendant, but yet the defendant did not appear. And then next is order 13 rule 8, the court may set aside judgment in default or JID entered for setting aside judgment in default of appearance. Okay, that is this rule usually, the court usually is being stated by the defendant. Okay, suddenly the judge, sometimes the judge might ask you, okay, if you're the defendant, you can tell the court, okay, you have this ground believing that the judgment in default of a parent can be set aside, and then the judge will ask you, you think I have the power? Okay, tell me which rule order in the court that states that I have the power to set aside the judgment in default, and then you state is order 13 rule 8. Alright, cool. Next. Oh, done. So basically, that is for our topic, judgment in default of appearance. This is not a very difficult topic, but these are the procedures that you need to remember. So basically, for judgment in default of appearance, you must remember this order 13. Okay, before you answer this order 13, judgment in default of appearance to read, it is important for you. Number one is to specify the type of demand. Is it a liquidated demand, unliquidated damages, or a claim indefinite, or possession of immovable property, or misclaim, or other claims? Because there are different rules applicable to this type of claims. And then the next important thing is the proof of service of writ. Okay, you must prove a certificate of non-appearance in form 12. Okay, and then the third thing that you must know is it is important for you to know that the court has the power to set aside the judgment in default of appearance. Okay, now I'm going to show you a practical. Okay, this is quite a common practice for a civil litigation lawyer to do in court. One of them is to ask for judgment in default of appearance to court. If you have a short call, okay, after 3 months of practice, chambering later, you can do this judgment in default of the appearance in the lower courts, meaning at the magistrate court and even session court. Okay, for you to enter into appearance, to enter a judgment in default of appearance. Okay, that's what we used to do. You know how during my time it cost like 1,000 ringgit for this type of application to the court. So this is what I want you to do. So basically, I want you to file the writ of summon and statement of claim, and then afterwards you file in the memorandum of appearance. Uh, in some cases, no. In you file in your service, okay, and then if there is no effective appearance, and then you can file judgment in default of appearance. Okay, so I just realized that I need to make some corrections to my instruction in one of our practical questions. Remind me of that, okay, Shami? All right, so basically this is what you are going to do. You got a mention date, okay, you before the mini trial start, mini hearing start. You go and see the interpreter, court interpreter, and then you say okay, you show her your course papers all duly filed and got the court case number, okay, it's stamp, and now you have e-filing. And then she will ask you, what do you want to do today? You tell her, I want to enter a judgment in default of appearance. Saya mahu masukkan penghakiman engkah terhadap defendant. Oh, okay, defendant tidak deserve, sudah deserve. Defendant tidak masukkan kehadiran, ya, dia tidak masukkan kehadiran. Okay, go to open court. Wow, and then you feel like, oh, this is my first time entering a judgment default of appearance in the open court. That's after the court interpreter, you have it like around 8 something in the morning. The open court will start at 9, and then your heart will be beating. Okay, that is your first time handling this judgment default. I want everybody to try this, doing this judgment in default of appearance. So basically, during that mini hearing, you stand up in front of the judge and say, this I want everybody to do. Yeah, as many as possible. So this is like a mini practical oral submission hearing. So basically you're going to say, oh, say in Malay then, okay? We make it simple. If he is a Muslim, say Assalamualaikum and selamat pagi, dan selamat pagi. Puan Magistrat or Tuan Magistrat or Tuan Hakim or Puan Hakim, saya Nur Zuhaidah binti Osman dari Tertuan Baharudin Ali & Co, mewakili plaintiff dalam kes ini terhadap defendant bla bla bla, nama apa. Untuk pengetahuan mahkamah, saman dan writ of saman dan writ saman dan penyataan tuntutan telah dihantar kepada defendant pada tarikh sekian dan sekian, dan affidavit of service, affidavit penyampaian telah difailkan pada beberapa hari bulan. Tiada kemasukan memorandum kehadiran dari pihak defendant hingga telah tamat tempoh kemasukan kehadiran. Oleh itu, saya memohon kepada mahkamah yang mulia ini untuk memasukkan penghakiman engkar terhadap defendant. Terima kasih, Tuan Magistrat. Okay, so the court will look at your papers. And sometimes he will ask you, semua dokumen telah difailkan dan dalam in order? Cakap, ya puan. Penghakiman engkar untuk defendant. See? Terima kasih, Tuan atau Puan Magistrat. That's all. As easy as that. It's less than 5 minutes. But you will give him, last time it cost like 1,000 ringgit. So, you can bill your client up to 1,000 ringgit or more. Okay, that's all I want to do. So that's all for today. Thank you very much. Assalamualaikum.